three most dangerous words in brain injury litigation aren't pre-existing condition. They're mild traumatic brain injury. I'm Taylor Ernst, 2024 California Lawyer Attorney of the Year. I've educated over 20,000 lawyers and doctors. I wrote the book called The Ernst Way. It's a book about how to litigate TBI cases, and I got a $63 million verdict. Everyone thinks when there's a mild traumatic brain injury, or there's MTBI, you've got a small case. It's the insurance way to value a case based off of how it looks at the very beginning, which you don't measure something that occurs over 25 years by looking what happens in the first 30 minutes. I know there's a lot of medicine and ideas and, you need to figure out if it's mild, moderate, severe. Yes, but that's only for the treatment. The jury doesn't care if it's mild, moderate, severe. They want to know how significant the brain injury is. To give you an idea of why you don't want to buy into this definition is I've gotten multiple verdicts, multiple arbitration awards where there's an MTBI and there's a very significant long-term problem with the client. And there'll be a head injury diagnosis or a concussion diagnosis, or sometimes not even that. A Glasgow Coma scale of 15, they'll be discharged the same day. And one specifically was a nurse who didn't even get diagnosed with a head injury. Even though she was rear-ended at freeway speed, she complained of left side pain in the ER. She went home and she was vomiting, but none of that got put in the records. And so the defense viewed that case as she's still working, she's still driving, she has 4 kids, Glasgow Coma scale 15 means normal. And I remember that case didn't settle, but in the discussions where we're trying to figure it out before it went to a verdict, that the defense kept telling me Glasgow Coma scale was normal and that all of her symptoms were normal. And I just couldn't figure it out, because normal doesn't mean, like, if somebody's got a bunch of symptoms from a brain injury that are still occurring years later, you can't say Glasgow Coma scale normal, CT normal, therefore person normal, when all the evidence you have of all the people and problems that they still are going through are abnormal. And so it's this normal equals normal that the defense is trying to put on, when it's really abnormal equals normal. I don't understand, other than they can make it very confusing by the medicine, why the defense does that. And so they basically, in figuring out how to try the case, the defense basically told me what they were going to do, which is they were going to read normal neuro exam, normal Glasgow Coma scale, normal CT scan as many times as possible, and then try and lump that into a bigger umbrella of that means no injury. And I couldn't understand why they were going to do that until I saw at trial, where they just were overwhelming the jury with the word normal. They said it over and over and over again. They'd look at every medical record and read the word normal 15 times, and then look at the jury and be like, did they get it? It was normal. And it was basically this whole concept of say normal as much as possible and try and have it inflate everything that mild TBI means gets better and is normal. When you buy into this idea of classification scales, the medicine that doctors are used to render aid for people who have a traumatic brain injury is based off classification. However, it doesn't discuss long-term results. There are some papers out there, just to be super specific, there are some papers out there that statistically talk about it, but then you're taking a statistic and expanding it to mean, this percentage might get better and this percentage doesn't, when we have records from 3 or 4 years of doctor visits and people around them and doing all this stuff why are we using statistics for a large part of the population when we have detailed information about everything about this person's life? So you don't want to buy into that statistics game. And taking a step back to what we were talking about is you don't want to argue classification as the reason a case is significant. It's the triage diagnosis. It's what medical professionals do at the ER trying to figure out what to do with them. So the hidden game for the insurance defense is that medical classification is how they quantify the significance. And you don't want to buy into that because that's for medical treatment. After somebody gets a brain injury, generally, there isn't significant medical treatment that's done immediately. They need to see what their cognitive problems are and then address the cognitive problems through either treatment or managing the symptoms. And so while you focus on the classification, you're not focusing on the value of the impairment on day-to-day life. So you can have impairment and still work. You can have impairment and still drive. You can have impairment. And to give an example of a verdict I got a week and a half ago, our client biked again and again and again after his brain injury. And the defense made this big deal of if you have brain injury, you shouldn't be able to bike. But they didn't come out and say it. They just inferred it over and over again. And we got up in closing and just said, why? This has nothing to do with whether or not he had a brain injury. It's a different part of the brain that allows for biking. And so when you lean into what the actual impairment is and talk about the impairment being related to the significance to the jury rather than the classification that occurs in the first 24 hours, you're giving the jury what they want. Classification doesn't help the jury determine how hurt someone is because they want to know, is this significant or not? Should I write a big number on the verdict form or not? And if you say, well, mild means anything from a heal in a day to, in the small, miserable minority, they have problems for the rest of their life, it doesn't make any difference to the jury. It doesn't give them facts that help. So the defense wants to measure medical triage terms as the moments that matter. And you don't want to do that. You want to measure the human moments of impairment. So what you want to do, how you flip the script, is you take the mild versus severe and you collapse the data to, it's only the first 24 hours they use for that. And so the defense is looking at medical records and we're looking at functional evidence. What's more valuable? What doctors wrote down that they only saw the person for 30 minutes after the incident when they went home and then they had all these other problems that all these witnesses talk about? It's very simple. And it's the reason that when I show the proof of not buying into this mild TBI frame, I can show on the screen or other ways that I've got verdicts of 3.29, arbitration 4.45, 5, 5.65, all with a Glasgow Coma scale of 15, some without even a mild TBI diagnosis in the ER. And there was no orthopedic injuries claimed on any of those. You understand that what you think and what I used to think of, like I'd look at the neuropsych report and see it says an MTBI and I'd be like, oh no, that means the case isn't that significant. It was just because I didn't understand the medicine. And once I understood the medicine of it's much more of a triage diagnosis designed to figure out what they need to do that day in the ER, and then you look at the functional deficits over time, you see it everywhere in all the litigation you ever do where there's any claimed brain injury going forward. Because you don't want to fight on where the insurance company wants you to fight. You want to fight on where you want to fight, which is the significance. And I'm repeating myself, but the reason I'm doing that is it's the frames that the insurance company asks you about, that if you speak in their terms, you inherently limit the value that you can prove your cases are worth. Because you're playing with the system they made up. And it isn't just about TBI cases. If the insurance says, well, what are the HAL numbers? Do you know what and that's in California for you and not in California. It's basically how much was paid by insurance companies for past medical bills. My response to defense lawyers and insurance adjusters is we don't value cases based off that. And they go, well, we need to check the box. I'm like, well, you've figured out. That has nothing to do with how we value cases. And if I give you a number and say, the verdict I got a week ago was 3.249 or whatever it was, our numbers that insurance paid in past medical treatment was like 30 grand. And the defense would look at 30 grand and be like, well, we're going to offer you 100, which ironically is what they gave us a 998 offer of. And we're just like, yeah, we don't care about any of that. And they're like, well, Glasgow Coma Scale 15, MTBI, it can't be that significant. And I'm like, watch what happens. So this podcast, the reason I'm doing this is I'm giving the information to all the lawyers out there who are interested in taking it to the next level. There's a lot of lawyers that will hear this and they won't really resonate with them or they don't really care. But this is for the 5% of you that realize I'm ready for something bigger. I want to make a change. I want to argue my TBI case at the highest level. I don't care if the Glasgow Coma Scale was 15. I don't care if the CT scan was normal. They're going to keep playing the insurance game until they realize they need to sidestep it and argue for what the human significance of the injury is. And then once they start doing that, you're arguing for the truth of what it is for your client rather than the statistical 30-minute eval of the doctor who's overworked and seen a zillion patient that day and is on the last hour of a very long shift. That's not where you want to go. You want to be able to find what matters to the jury at the end. And what matters to the jury at the end is they don't care about the classification scale. They just want to know, is this a big case or not? And you give them that information and they'll reward you. I'm Taylor Ernst. Thanks.